Estate planning for collectors. Collectors could be collectors of art, some type of memorabilia. It could be baseball cards, basketball cards, sports cards. It could be automobiles, classic cars. Some of those items are titled assets and some of them are non-titled assets. Art, you can get a certificate of ownership for the art, especially high-end art pieces, pieces that have some substantial value, sculptures, as opposed to, though, automobiles which have titles. You may have a title for a classic automobile, and those would be handled maybe a little bit in a different way, but should be handled under a proper estate plan. There's multiple reasons for this. One is establishing ownership. So just stating that you own this piece of property, especially with a non-titled asset like Michael Jordan's rookie card, or a Monet or Renoir. Or if it's a classic car, some classic cars over a certain number of years old might not have a title. I've seen that happen a number of times. But also you can generally have titles issued for those vehicles. And at the very least, you can state that ownership in an inventory and refer to it in a last will and testament, or perhaps a trust for those assets. A trust can handle the transfer of memorabilia, of collector's items, of art, of classic cars. A last will and testament can do that as well. The key is that you empower the executor with a nice inventory of the assets, or the trustee in a trust with a nice inventory of the assets, and then state clearly what the trustee is to do with the assets. Another important element of this is avoiding excess taxation. Say that 3 times fast, excess taxation. And that is from a capital gains tax perspective. A last will and testament and a trust both afford you the ability to exercise the option to step up cost basis, also called taxable basis. That's how much you paid for that piece of art, that sculpture, that classic car, or that baseball card or basketball card, Michael Jordan's rookie card. Imagine what that would be worth today versus what you paid for it, 30 years ago. You can step up the taxable basis, the cost basis, and give your heirs or beneficiaries the current fair market value or appraisal value at date of death, which means if they sell that piece of art, classic car, collector's sports card, something like that, then if they sell it for the same value as it appraises for at date of death or more, it will minimize the capital gains versus if you leave that cost basis by giving it to them during your life. That's the danger of giving assets away during your life, is you're giving them the cost basis that you have in the asset, which means if they sell it, they're going to have a much larger and higher capital gains tax. Avoiding capital gains tax is part of estate planning, or at least minimizing that tax by taking advantage of passing assets through last will and testaments or trust. I would encourage you, if you're a collector, to get your affairs in order, or at least sit down and have that discussion with myself or one of our trained attorneys. I would offer a free consult to have that discussion with you. You can call 1-888-999-6600 to take advantage of that consult, or you can schedule right on our calendars online at mcelderlaw.com/scheduling. That's mcelderlaw.com/scheduling. Thank you and happy collecting.
Please don't wait.